One of the most common questions we get at our office is, do I really need a trust? Trying to choose the right estate planning tool to say who gets your property and how it's going to be distributed. So in this video, I wanted to unpack just why trusts would be recommended in situations and how they're beneficial tools for the right people. So generally speaking, I like trusts, especially in Kansas. Some of the primary goals of estate planning is, as everyone's thinking about, how your property is going to be divided upon your death. Who gets your stuff? The second one can be how easy or difficult is it going to be to divide that property? And then third, a very important one is who's going to be in charge of facilitating what I want to happen upon my death? Choosing those responsible parties. Now, with those three things, there's more than one way to get things done, is that you can write a will, and that does say how you want your property divided, but it really fails the test of how easy it is to administer. Wills require probate. Probate's expensive, lengthy, messy, open to public, higher likelihood for disputes because they're so easy to create court battles in probate. Another option that may be tempting is relying just on beneficiary designation, saying on my death, just transfer the account, write the check to this person. What that skips is there's no responsible party who's in charge of facilitating your estate. People get checks at the end of the day. That may be beneficial for some people, but where that fails is, what if we need to pay some bills? Who's paying for the funeral bill? What happens if the person we named on the account isn't around? Things start to fall apart at that point. And this is where trusts come in because it's meant to address all three of those in one document. If a trust is set up properly and designed properly, it's intended to avoid probate court. So that's step one. It just keeps the administration process out of the supervision of a judge, out of the public eye, making it very easy for the parties involved to have court battles. The second thing is it appoints a person who is in charge of your affairs, who has your funds first before all the distributions are made to where we want it to go. And because of that, we have a responsible party who can go use your money to first pay the funeral bill and pay taxes. That way no one's shortchanged. No one has to pay out of pocket to cover your expenses. And there can be less battles about how we're going to cover these funds. And the third thing is it covers all these contingencies. We're no longer depending on designated beneficiaries to be alive because the trust will have these backup provisions. What if this person's deceased? What if they're incapacitated? What if they're out of state? What if they can't do it? The trust covers a lot of backups. It can also protect much better than other documents if we ask the questions of what if this person is bad with money? I have a child or an intended beneficiary who has a spending problem, has a substance abuse issue. They can't have money. A trust is really good at accommodating for someone who you want to give an inheritance to, but who should not otherwise be receiving funds for whatever reason. If they're minor children, you don't want to hand them a big check. If they're disabled, maybe they're incapable of managing finances. If they're otherwise bad with money, if they're immature, they've got, on a heavier issue, if they have gambling issues, if they have substance abuse issues, those are great reasons to not put money in a bank account of someone. Trusts are really good at accounting for that. Using the trust mechanism, we can put someone else in charge of their money. It's still your intended beneficiary's money, but someone else has the checkbook, someone who you get to pick, who is responsible, good with money, that you would trust with those trust funds to say, use this for this person, cover their expenses, but don't do it in a way that's going to kick them off of government benefits or ultimately cause harm. Those are just some of the resources available for trusts and why I like them. It's a combination of accomplishing several things that I hope to help my clients with. Appointing the right people, making sure that when it comes time to administer your affairs, that it's going to go as smoothly and cheaply as possible, and then making for a clear, documented division of your property and still covering all of the what ifs. That what if the people we do have intended aren't around, aren't capable, don't receive the money. I don't always recommend trusts for everyone, but trusts can be a very helpful tool for anyone who's trying to solve any one of those problems, which can be most of us. If you're in the position where you're thinking that you want to arrange for an ease of administration, if you want to make sure that you've got a clear line of authority of who's going to be administering your affairs. If you're wanting to make it to where it's not an easy court battle, that they have to duke this out in front of a judge, and you want to have a lot of backups or protections for your beneficiaries, that's where trusts really shine, and why they're helpful tools and why you hear about them quite a bit. The other thing is they stay revocable. A revocable trust, also called a living trust, sometimes called a family trust, they stay revocable during your life on purpose. And that means they're easily updatable by you. You can come back and say, I changed these divisions, I changed my trustees, I changed the order of something. You stay in the driver's seat about what's going to be happening with your affairs after you're gone. So, when used correctly, a revocable trust provides protection, clarity, peace of mind. It can be a go-to tool to allow for an easy administration. If you're wondering whether a revocable trust is right for you, that's exactly the kind of conversation we have with clients every day. Give us a call.